I want to imagine that in lifetime, everybody tries as much as they can to acquire property for their own use, as well as to leave a legacy or to make sure that the people who depend on you are left with something out of your sweat. Quite often, and in this country, especially in Kenya, we have seen a lot of public figures when they exit the scene. We've been treated to a lot of drama. Sometimes we've had cases of family or beneficiaries being in court for close to 30 years. It's highly doubtable that anybody would wish to that scenario to befall them after toiling every other day to accumulate what you can. It is on that background that we would wish to examine what is it that one can do. I have my shares at a given circle. I have instructed Vasili to invest for me in this manner. And then I sit down and say that now that I have made these investments, what is my wish? What is my intention? How do I want this property to go? I am looking at a scenario where I say I am going to use a third of my property, and the 2/3 of my property is going to my beneficiaries, my parents, my children, my spouse. How do I then control that investment? The question we need to ask ourselves is it my wish here to accumulate all this wealth? Then whether I'm alive or when I exit, I leave it to anybody to do what they want to do with it. And that now brings us to the question of, after the investment, what we call estate. Estate in this sense is the free property of somebody who has passed on. And this discussion will center mainly on what you can do in your lifetime to take care of your property or to make your wishes known and adhered to when you are still alive or even when you exit the scene. And my discussion will be based on the law of succession in Kenya, but basically what it recognizes and what does not recognize. And from there, we see the ways of making your wishes known to the rest of the world. And what is it that who may or may not share in your estate? That is basically our discussion, where estate in this case is the free property of an deceased person. You have already accumulated. Now you want to determine how it goes when you are alive and when you exit the scene. One of the ways you would control your investments or make your property go to the person you want to go to is by what we call intervivals, or during your lifetime, you can decide to give your property to whoever you want. You can actually transfer a piece of land to say heir and say that this one I'm giving to her, even when I'm alive. It is, I know it is surely tricky. Sometimes you don't know how long you're gonna be in the world. Yet once you transfer that property when you're alive to say heir, it becomes heir's property. And you really have no say because you have said, I'm gifting him. I'm gifting her this property, I'm gifting her this car. And from there, you cannot really claim any other rights on it. And you don't know how long you're going to be around. So that makes people at times look at it like, wacha ningojea kidogo, let me wait a bit before I give my property. The waiting is both ways. You don't know how long you're gonna be there, and you don't know how short it can be. So that's one of the sure ways of making sure that your property has gone to wherever you want. And the law recognizes that if you gift, say you have 9 children and you gift one with this, absolutely when you are alive and you transfer it, that is recognizable. That's one of the ways you can do it. There's another way. There are other ways where you can pass on property, but it will become effective only when you are gone, only when you are dead. I know it is most of us in our setup in this country and most of the cultures, we don't like imagining that one time we will be out of this scene, but it's a reality. And we have seen what death has brought to some families and to some scenarios which are not very palatable to anybody. One of the ways the law recognizes is called nomination. And nomination is prevalent in cooperative societies where one has shares, or in investments where you are required to name somebody or people who will be able to take up your shares if you are, for one reason or the other, you are deceased. And we call that process nomination in law. And the law recognizes that if you nominate heir to take your shares in a cooperative society, all the cooperative needs to do is to know that you are dead, and they see evidence of death, which is a death certificate, and they will pass over the shares without any other process required. They don't have to wait for court process. They only need to present that evidence of your death, and the shares should ideally and immediately be transferred to them. This nomination process, at times, people have problems with it, in that they don't think that they're in control of the property anymore. But let me assure you that once you have nominated somebody and properly done it in accordance with the investment policy or the cooperative society's policy, it does not mean that you have given that person your property. It only becomes effective if you are not there. If you decide that tomorrow I want to sell my shares, you will do it freely. So it is only available to the nominated person. Sorry, there's some noise from my end. It is only after that nominator passes on that the nominee will benefit. So there's no worry that I'm naming people here and they have taken my property. They will not take it when you exit, because you are controlling it while alive, but effective on death. The second way of doing it while you're alive, but to take effect when you are dead, is through survivorship. They are what we call joint ownership of properties. And it's a common scenario, especially for matrimonial properties. You find that spouses are registered jointly. Their names are in a property where the matrimonial is jointly owned, as opposed to owned in common shares. Those are fairly technical terms, but definitely where you are owning a property jointly with somebody else, say your spouse, and it does not state who owns 20% or 80%, we will treat it as jointly owned. And if it is jointly owned, survivorship presumes that if one of these people passes on, the person who remains alive takes up the whole property without necessarily having to go through court process or anything else. It is one of the ways I have seen work very well, especially for spouses, such that if you pass on, you have registered the property in a joint way, it passes on to the spouse. The third way is something we call gifts in contemplation of death. One might ask a question, who contemplates his death? But in life, there are situations you find that somebody is either very ill or is going into a situation where he says, I'm not certain that I'm going to survive this one. You're going to an example, and I'm not saying this is an exact position. You are going to a theater of operation, have been unwell, and you say, I am not very certain that I may not survive this. So, Ross, I have these keys for my car, I have that car. In case I don't come out of this, that is your car. Now, these gifts must be clearly understood as opposed to the gifts when you are alive. Because gifts when you are alive, you are giving absolutely. These ones, you are contemplating death. And if death does not occur, you actually have an intention of getting back your property. But if death occurs, then the person who has been given that property, and the property must be given in a proper manner, that you have actually been put in possession. I have these keys of my car. That car is yours in case I don't survive this situation. If you survive, you can still get your property. If you don't survive, that person can have that gift without necessarily having to go over any other approval by anybody or even the court. There are some conditions, and the law of succession, of course, as is wider than maybe the summary I'm giving. There are some conditions which are attached to that. One, if the person giving the gift commits suicide, it is not considered as a proper way of passing. You cannot now claim that gift because suicide is one of the ways which disqualifies a gift in contemplation of death. So it is conditional on death, and it is the person giving, the donor of this gift must also have exercised his right to take it back if he survives that death. The fourth way of passing on your estate while alive but effective on death is by way of what we call testate succession, making of wills. This is a fairly common way as opposed to the first three I have discussed. But it's also as its own, from my own experience and from my interaction in the court, and what happens is wills are largely misunderstood by many people. Some people feel that if I do a will, I have again given out my property and I cannot use it. I have been instructed by a client and he tells me, will out this portion of land, but leave a small portion for me when I'm alive. I'll be using that. In his mind, he is thinking, by making a will, you have actually given that beneficiary the rights to your property. No, a will is dead until the maker of that will passes on. So it only becomes effective again once you pass on. And there are some conditions, there are some ways of how a will becomes valid, because that's why you find that will be meant and invalidated by the court. So your wishes, you can sell even the property you have put in a will and change it the way you want. You can change it today, you can change it tomorrow, you can acquire more property and still put on the will. It is your document. It is your document basically, and it's your property until you exit the scene. One of the things I must point out before I go on is that in the will, you cannot put things you have already given as gifts in the contemplation of death. You can't give property you've already nominated beneficiaries. You can't, again, put in the will property you've already passed on to somebody when he's alive. This, you put your wishes and your intentions on the free property. What now you have. Once you have nominated somebody in an investment, that is not part of your property. You can put in a will. It is not part of your estate. Once you pass on, that's not part of your estate. So let me go very fast to the questions of requirements for making a will. And one of the requirements is that you must be of age. That is, minors are not allowed in law to make any will. It must be meant out of your own free will. Nobody should coerce you. Nobody should influence you in making that decision. Although you might, somebody can entice you, and that might not necessarily be wrong, but it is a free document. It is not a document where you go to express your emotions. It is actually a document passing on property in the case of your death. You limit it to your free will, your property, and it must be as simple as it can be. Let no ambiguities be there, because the ambiguities are the ones which invite people to fight and now go to court for invalidation and such. Let it be very clear that I'm giving my portion of land in Mombasa, around this number, to so and so, without an ambiguity. It has to be simple and clear. Once making a will, the will must be witnessed, at least by 2 witnesses. And this ensures that once you exit, these witnesses can authenticate that I was there, I signed, I saw him sign. And you must affix your signature or mark on that will to show that this is my intention. I have understood the will, and I'm the one who meant this will. At times, there are people who cannot do written wills, and they also not want to do an oral will. If it is you direct somebody to write it for you, and it's read to you, and you confirm that is what is written and is witnessed, it is as good as what you've written. Secondly, a will can be invalidated if it was meant out of mistake or undue influence or fraud. So you must, while making your will, you must be able to say very clearly that I've made it of my free will, and this is my property, it is going to A, B, C, D, without any ambiguity or expressing your emotions in it. A will can actually be oral, and an oral will is as good as a written one. It's only that it's required that if you are making an oral will and the witnesses are two and they witness it, the maker of that will should of necessity, I'm using the word of necessity for lack of a better word, but must pass on within 3 months. Otherwise, if you stay for more than 3 months, that oral will is invalid. It's meant in a way that it's like also you are contemplating that my things are not going so well. Let me just make my wishes known. I call them A and B, or Madam so-and-so, they see what I want to be done with my property. So oral wills can be effected as long as all the conditions are met. And again, there is no undue influence in making of that will. It's important to note that a will can be deviated with by the court. At times, you have the freedom to will away your property, but this freedom can be interfered with. There are situations where wills have left out, say, beneficial heir, and there's no reason you are giving. You have actually a right to say that I am not going to give my child number 2 anything because he's been beating me. He's been a bad person to me, and everybody will respect that. But if you decide that I'm not going to give my child number 2 anything and you keep quiet about it, that child has a right to go to court as independent and seek to be catered for in your property. And that is how things start now getting messy. Your hard-hand property, your wishes have been interfered with because of technical issues or not being very clear in your way. If you disinherit one person who is your independent, make sure that it is very clear why you are doing so. Or alternatively, you make it clear that I am not going to do this because I have given so and so a land in Makueni, for example, when I was alive. So he's not going to get anything else. That will be respected. But the courts can say that you decided to go and give your property for maintenance of Nairobi National Park, and you left your minor children and your spouse without anything. They will interfere with it and say that we must give them reasonable provision while giving you the freedom to say what you want about your property, but we can interfere with it if you make such blatant omissions. We've discussed all these things about the will and how you need to make it effective. That one we've discussed. So we look at the advantages of a will as opposed to lack of a will, which we'll see under what I've called intestate succession. The importance of having your will is a bit obvious, if you ask me. It might be scary because of our cultural inclinations that some communities will think that if you start determining what will happen when you die, you're actually inviting death. No, there are advantages. One is you have the freedom to decide what will happen to your property, freedom to dispose of your property the way you want. Of course, we have given some variations in what you may not be able to do, but you have the freedom to say, my car will go to where, my land, my house will go to where. Your freedom. You're not leaving it to third parties, courts, lawyers, auditors to come and determine what happens to what you hand. Those mornings you used to wake up and walk, those mornings all those things you pass through as you accumulated, then you leave it to other people to determine how it goes. I don't think it's right. So the advantage of making a will is you freedom to dispose, avoiding confusion and squabbles when you are gone. Immediately, a testator or somebody who has made a will is gone. The people who you appointed, the following day or another day, can call the beneficiary and tell them that, look, this is what your dad said about his property. And that way, unless, of course, there are those instances where people disagree, and even if they disagree, they don't have a direct right to the property unless they go to court. And even then, they can fail as long as you are very clear in your will. So you avoid scrambles on death. You avoid transferring malice. People start fighting over your property when you're not there. Your wishes are well preserved because you have stated them. You can actually bequeath property to friends and other people, or even to institutions like charities. But if you leave your property without making it very clear that Mr. Kioko was one of my best friends, I think I should be able to gift him with this. That will be respected. But if you don't do anything, even if your intention, even if you have told me many times that once you have been too good to me, you have been a good lawyer to me, I think one day of these days I will do something good to you. If you live without making a will, that it is in your mind, it is your intention, but nobody will going to respect that. The other advantages of making a will is you choose your trusted people to execute your wishes. You can name the people who are going to ensure the division of your property in the will. And those people are called executors, will come in after you are gone to divide the property according to your wishes. So you have chosen, you are living your dream even when you are gone. You are living your wishes through your trusted friends, through your lawyer, through your auditor, through your neighbor who you trusted. You have chosen him to take charge of your property. So there is no wastage of time. Once you are gone, we know that it's very clear. And it has happened many times. It's only that by the very nature of how we get information, we only get to know the bad side, where people are fighting over their late dad's property. But it happens many times. We have seen many times, we as lawyers, we have sat with families many times, and it has been sorted out. The executors have done their duty, and everybody is happy thereafter. We never get to hear of those things, but they do happen. There is also another misconception where people think that because I am not very wealthy, I don't need to do this. Let me tell you, it is not just the public figures who are wealthy where we have issues of succession. Indeed, I would say that the unreported matters where people fight in court for 1 acre of land for 10 years until they are unable to benefit from it are many. They are numerous. Our courts are full of fights on these properties. So when you make your will and it's respected, you sort out some of those issues. At times in the will, you can also provide for where can I be buried when I'm gone, and how do I, how am I going to be disposed of? This I'm putting a question mark because sometimes you really, it is left to your executors to carry on your wishes, but they're not really legally bound because we say there's no property in a dead body. But there's beauty in knowing that I have liked this place I have put up in Molo, and that is where I would want to, like, we put it to rest for eternity. And then the executors can do so. Other than having Wazes to sit down and determine where do we take him. He has 3 homes. Where was he liked most? No, you clear those confusion at once and for all, and you are still living. So the last point I would want to emphasize is we have had situations where we accumulate wealth. We don't tell our spouses, we don't tell our children, we don't even tell our friends, or we tell 1 or 2 friends. and nobody knows when death knocks. And then nobody knows that you have a huge piece of land in Yatta. You only know yourself and the person you bought from. Then you are gone. The person waits for 3 years, 4 years, you don't settle, it is gone. That if you make a will and you know, of course you know all your properties, you will not have a situation where your property just goes to people you don't intend to, because you will have catered for every part of your estate in the will. So I would really emphasize that the effort you put in accumulating your property should also be put in ensuring that it benefits you and it goes in the right way and in the manner you would have wished if you were still alive. Now, the last bit really on how to plan your estate is not really a way of planning, but I'm bringing it up so that you can know what will happen if you don't plan your thereafter. You don't plan your property when you are gone. And that is what we call intestate succession, where there's no will or where a will has been invalidated. All parts of your property are not catered in your will. There are some situations where you can make your will, then along the way you acquire property, and somehow you have not done an amendment to your will or done a codicil. That property now becomes part of what is called intestate succession. And this is now where you have left other third parties to determine what to do with your property once you are gone. Intestate succession really looks more to benefit what we call blood link relatives, spouses, children, sisters, brothers, parents. But the law recognizes the people to be given priority, that is the spouse and the children. In intestate succession, the spouse carries a very big part of it and has the first priority to apply for what we call letters of administration, and now be given powers by the court to administer your property in the way they want, as long as they adhere to the law. And this is this is where I was saying that there are disadvantages in this. So you have left it to your sons and your spouse to do what they wish with their property, and this is where many times we have run into problems. Now, what happens is the law states that if you die intestate without a will, your free property should not be meddled with, or rather nobody should come in and do anything. Indeed, nobody can sell your land, nobody can sell your car, nobody can do anything with it unless the court has appointed them as personal representatives. And that is now you can see the time which is going to be wasted. But because it's a scenario which is common, which plays all the time, it is important that we also look at what happens then in intestate succession. And in people, the beneficiaries, usually the spouse and the children sit down and appoint one or two of them to go to court and apply from the court to be appointed as personal representatives of your estate. They will list all the properties and all your liabilities, and now the court will look at it and say, fine, what is your relationship with the deceased? I'm the wife, I'm the husband, and we have these children. Then after you applied to court, because things are murky, you have left things in that state, you apply to court, and then it has to be put in the Kenya Gazette for 30 days, so that anybody else who thinks that he was your son or your wife, or he was dependent on you, can come out. Now, let's see that they have applied for letters of representation. I also need to be put here because I'm his son. And that is now, it is now building up. The issue is building up. They have a right to say, I have not been catered for in this application. I need to be included. So the court will also determine whether these people who will come are put in the succession battle. You see, you have many applications, some of those are scam. Many times people don't come up. Some other times, many people come up and say, I was also his wife, I was also his son, and I need to share in this estate. So after that days, if nobody comes up to object to the succession, basically what happens is the people who have applied will be provided with what we call the letter of administration and grant to administer the estate, in which now their duty is to go ahead and pay all your debts, make sure that all your properties, try to go through your wardrobe, go through your lockers to see whether there is anything written, shares at M&M Advocates, for them to scrabble through, to piece together everything which you might have owned, and they put it in that process so that they can now be saying that we have now paid the debts and we have now have a net estate, or rather the property remaining is 1 million. Now, after 6 months, after they have done all that, they are now supposed to again to go back to court and do what we call confirmation of the grant, in which process now is they show the division. We have now decided, according to law, we are going to divide our property in this manner. The court has to approve or disapprove. And if during the division also there are squabbles, the court will hear everybody who is not comfortable with the division. The basic rules, because these are a very wide topic, the basic rules are that the spouse, and the spouse here, we have to be extremely clear that it's a married wife, and a system either customary or through the registrar's office or through church. It has to be a wife proper, not anybody, because you will be required to prove that the local chief or the local association will have to do a letter to court saying that these are the people we know who are the children and the wives of so and so. So the wife is given a priority in the sense that it is said in law that she has a life interest in the estate of the husband, or the husband has a life interest in the estate of the wife, meaning all the properties, whatever comes from them, they can have that property, benefit from it. The children have what we call equal shares. It does not matter whether the child was out of wedlock, whether the child was adopted, whether it's a female or male, the law treats them equally, and the property should be divided equally. This is where I was saying you have left it to third parties to determine the fate of your sweat. Now, at times, some of the people, you could be having a dependent, a brother or sister who is not provided for in even the letter of administration. They also have a right to go back to court and apply to be given a reasonable provision from your estate, even when they are not put in the succession. So anybody who was dependent on you, and that is why it is important that you could have identified them in your will. They will come up and say, I'm able to prove that I was relying on Mr. Kioko, and I need to be given something out of his estate for my survival. But this is subject to a serious test, whether indeed you are a dependent of that person. Now, there's a question which keeps on cropping up, and I must confess that for a long time we have also had a lot of mixed up approach, and this is where people say that according to, say, Luo customary law, this is how we divide our property. Let me clarify that yes, the law recognizes customary division, but it is very limited only to areas which have been gazetted by the government. And from my research, only pastoralist areas have been, a few of them have been gazetted to have the law, customary law applied to their livestock, land, and agricultural produce. But in all other cases, I'm sure many of you might even have encountered situations where a court followed actually customary law, even in a division of property in Nairobi. And the actual position and the learned authors who have written on this subject have said customary law has no place as long as you are not among the gazetted areas. Like I know Kajiado was, Saburu was, but if you're not in those areas, then the law of succession will apply to your estate fully. And the question of, I'm the firstborn son or the lastborn son will not arise unless good sense prevails. And we say, my mother had brought me up to the level where I was able to hand on my own. Let me not get as equal share as my young sister who is still in college. Unless that prevails, everybody who is a son or a child of the deceased person, whether adopted, whether born out of wedlock, should get an equal share of that property. So we have discussed in passing the question of dependents who can apply. There is also an area which brings out of confusion in the estate succession, and this is where we have marriages in the courts. I have been living with so and so as my husband. We've not conducted customary marriage, or he was already married under statute, or rather in the church or at the AG chambers. Then what is my position? And I'm actually reputed to be the wife of so and so. We have children. Sorry, the problem with the estate succession, if there's no will, is you are now put on your defense to demonstrate that I was actually a wife for purposes of this succession. Many courts have even held when they are dividing this property. Your children are the children of the deceased. But sorry, you are not a spouse or you're not a wife for purposes of our division. We have had such decisions. The only time I think such voidable marriages, I call them voidable because they are marriages in the courts. Can somebody move the court under the independency provisions? And even then, you are put on your defense to demonstrate really that you were independent. It is not a very pleasant situation. Unfortunately, that is one of the most prevalent situations we are encountering in our courts, in the instructions we get, in arbitrations which are always going on, calling angles to come and arbitrate on such issues. Luckily, you can actually prevent all this if you do a will or nominate or give your gifts, and you have sorted out all these embarrassments or these fights. You do not want to perpetuate hatred and the fights when you're not there. You better fight your own fights and go to your maker when you've sorted out your issues. So intestate succession is a bit murky. It can be avoided, but if it cannot be avoided, then you will have to take your beneficiaries. Your heirs will be taken through that process. The waiting, the mess in knowing whether this property was owned with B, or all that kind of untidy situation. Before we go to the questions, let me just summarize a few fears we encounter. Or from my experience, I've seen people have questions, a lot of question marks. Of course, I'm not trying to answer every issue on estate planning. The law of succession is wide. It is getting wider as we go along, because we are also having different relationships which we are not catered under our law of succession. For example, same-sex marriages. They may not have landed here. They may not have been accepted here, but they are coming. They are out there. How do we then treat such? What happens if there is no will? What happens? Will they be treated as husbands or wives? All those questions are coming with us. It's expanding. It has already been a difficult subject, and it's getting even murkier with the kind of relationships which are coming up and which we must be alive to. But to allay just some small fears people have, when you are doing a will or nominating or even gifting somebody, unless it's a complete transfer, the property is your property. You can use it and infinitum. You can use it from today. Even sometimes the people you have actually intended to give, sometimes even predecease you, and go on before they can be able to benefit from the property. So it is your property. There should be no fear that if I do a will today, that I have given out my property. It is conditional on my death. So it will be clear, a will does not deny you anything. You can take it back, you can do anything. That must be extremely clear. If you disinherit, or if you decide that in my will, I'm not going to give Kioko anything as my son, then you must be very clear why, so that you do not have a situation where your will is being interfered with by that person applying for reasonable, we call it the reasonable provision. Make it very clear, I am not giving in because of ABCD. Be very clear in your intentions. Don't be held as slave by anything. If the reason is because he beat you at one time, it can be a good reason. Then, of course, I've discussed customary law is very limited in its application. It's been a very, very big misconception all the way, even in the courts, that if a polygamous family comes my way, I will do it according to how the Kamba customary law says about polygamy, for instance. No, the law has provided for how these polygamous marriages are to be treated. And unless you are in those areas which have been gazetted by the government, and I could be wrong, but my recollection, the last time there was a gazettement of any area must have been 1981, when the pastoralist areas were identified. All the others, you must be very clear that customary law is very limited in application. A son, a daughter, if there is no will be treated the same way in terms of distribution. So my conclusion is that we toil every day. We make money, we acquire property, we expand our horizons, and we want our legacy to remain long after we are gone. The question is, after making the money, after making the property, do we ever sit down to address the question of what happens to my efforts once I exit the scene? Do we ask ourselves, and should we ask ourselves, do I care what happens to my child who is special, maybe disabled, and I have property and the others are okay? Do we care to see how can I provide for this person? How can I provide for my mother in the event who has been relying on me in the event I am gone? It is really disheartening to see squabbles over property once which you acquired or somebody acquired very painstakingly in their lifetime, denying yourself many good things, and then you are leaving it for people to come and just, decide what to do with it. It's a challenge. I will pause to the audience that you have that power to decide what to do with your car, with your property now, and even thereafter. Thank you so much. I think that's the end of my presentation. I will want to take the questions so that we can have a discussion. Law and social setups are very dynamic. I could even get suggestions. I am more open to suggestions. Thank you.
Thank you so much for the enlightening training. We'll now move to the next session. That's if there's anyone with questions, but there's one question for you.
Yes, please.
There's a question from one of the members asking that, okay, there's usually a document that is necessary for family, to prepare for families, that just clearly outlines or sorts the family members on how the property should be distributed. So the question is, okay, the person does not remember the name of the document. It's from Munene, and the question is this document legal? And if yes, how necessary is it?
I would say that as long as that document meets criteria for making of a will, one, it was meant by somebody willingly, and it has been witnessed, and it's clear on the wishes. Yes, it's a will. A will does not have to be a technical document drawn by a lawyer. As long as it has met the criteria of a will, then yes, that would make a very clear will of the deceased. Secondly, we also have sometimes some documents which even family members discover long after the deceased is gone. And we, like I've said, this topic is very wide. We have situations where you can go to court to have that document proclaimed as a will. Sometimes we have documents which are not wills, but which the court, after considering all the factors, can actually can say that this qualifies to be a will of the deceased, as long as it is proven that it was written by him and it was of his free will. So the burden is on the person coming to say, I think this was my mother's will. It does not look like a will in the legal sense, but I think this is my mother's wish. If you meet the criteria to show that indeed it was our intention, the court can actually do what we call letters of administration to propound that as the will. So yes, those documents can be effective.
Okay. Thank you for that. Is there any other question? Thank you for the training and for those who've showed up, because I think it's actually important to do estate planning. Most of us do not think of the afterlife, and it's just good to ensure that you've gotten all these things under control. So I think we've come to the end of this training. And I thank you for all those who've attended, and thank you, Mr. Kioko, for your time and for your knowledge.
Thank you so much.
Thank
Bye.
Okay. We shall share the presentation at the end of the day to those who had signed in. Yes, asanteni sana tena.
Thank you.
Thank you, Mr. Kioko.